all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this house, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion, Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the deputy president, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the deputy president saying that, there's precedent. There is no precedent in our courts in terms of impeachment. There is precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the deputy president first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, is a strict legal process. You have to show and demonstrate that the deputy president, has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office, of it taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment, and 2/3 if it succeeds in this house, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the Deputy President in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the Deputy President suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are 2. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied. The justification cannot stand. And indeed, Mr. Speaker, once one of the senators asked for the justification, and I heard the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was paid here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the deputy president on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruptions. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the Deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outspan, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibits, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision in Asset Recovery Agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the documents filed by the Deputy President, there is not a single document that shows that this judgment has been set aside, has been compromised, or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there's good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, they entered some sort of negotiation, is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of the Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss whom he has accused of being behind this motion. He would not actually work with the cabinet where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage, and I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, Honorable Senators, Honorable Speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa muongoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, na mwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliwachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa aende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yuozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga. Mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka station ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa deputy president. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa. Na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath, confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the Deputy President, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a Deputy President. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. we do not have to have beyond one. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir.
Thank you.
We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media and live broadcast has to cease forthwith.
Mtakuja kuona baada ya miaka 10, 20 mtoto mlemavu anakuja na bahati yake.
Nasema heko sana KBC, sio all television zote zinaongea mambo ya disability.
For every beautiful human being, you see it in a special child.
Mzazi kama mimi na kutembea na mtoto kama huyu for more than 20 years, it has taken a lot.
One of my greatest satisfaction is when I see a parent coming here with their child to do hair, and will take even 3 hours, something will take 20 minutes, and the child will leave looking so beautiful and satisfied, and the next time they also want to come and do their hair here as the salon.
We're here because times have changed, and family ownership of a franchise is no longer viable. It's time to sell the team, Dad. This isn't personal, this is business. If you read the reports, you'd see.
I'd like to speak privately to my wife.
Ex-wife.
You see Mr. Cornell through the door? Hey, whoa, just a minute there, Arthur. Because my lawyers can be ruthless as well. Hell! You could throw me out, Frankie! But I'll be here when you get home.
Let's hear those cougars roar, roar!
You are making a big mistake, lady.
So you're gonna prey on her weakness for you to stop her from selling the team?
Believe me, I have.
Frankie! Ambaye ataongeza katika jambo letu hili, yani Uislamu, kisichokuwa ndani ya Uislamu, basi atakuwa ni mwenye kurejeshewa.
Tuangalieni mambo ambayo kwamba yatasaidia katika umma, si kutenganisha umma, bali umma tuulete sehemu moja.
Siku alosawa amini kukangara ulimwenguni.
Mzee, uliingia ndani?
Mimi niliingia ndani.
Ukaona nyumba?
Mimi aliona.
Ilikuwa inakaa namna gani?
Nyumba ilikuwa mizuri.
Ilikuwa mzuri? Kwani ulitoka nje?
Sasa si mimi nilikuwa naona na nilikuwa bado kumalizika. Mimi angeingia kama bado pako rent.
Ukipewa nyumba yako unatoka nje kwa nini mzee?
Kwa nini? Unaona? Uko na oshako?
Hiyo ni nini?
Aruti oshako mheshimiwa. Ocha.
Mtu kama mimi niko na akili. Nilielezewa mpaka jinsi ya kupata nyumba affordable, nikashangaa mbona nilikuwa naenda kwa mikora kama hii.
Nyamaza, shut up, I'm talking.
Wewe. Acha kutumia lugha zingine zile, tunakuwa tunamwambia shut up.
Mimi ni architect. Architect ule wa kutengeneza nyumba mjini.
Hata architect sio kutengeneza nyumba bwana, ni wa kuchora.
Okay.
Uliza maswali ambayo itakusaidia.
Mimi ni seremala. Kati ya hizi vitu watu watatu, nani alikula kai pesa?
Ni Ngwiri.
Basi.
Ni Ngwiri Enterprise.
Nisaidie na kipoko, nitakuchapa.
There are no victims. You only have clients or clientele. As soon as she lands here safely, she'll be the next client. Sasa, what does Trish have to do with this?
Nakapua masikipua.
So you still have feelings for this girl, don't you? Trust me, not at all.
Wangekuwa nafanya kazi pamoja, will know.
Knowing is one thing. Would you tell us?
Aliniambia ataniletea mapasta. The following day akakuja na mganga.
Uwe msichana wewe.
Unisikize na unisikize kwa makini.
This sounds like one of your feuds with her.
You wish.
She has moved on. Seek her to move on, Twenty.
You can sing like this. Atoti, sonoka, sonoka. Atoti, sonoka, sonoka.
Ati kumwamini. Yaani waamini mwanaume. Ache sasa.
Kama hii song inaiba kwa mwendwa wako Mariro. Mariro, yani that rap song.
Kinyanjui, is that a rap song?
What I mean is punguza umama. Wacha wasichana tuongee.
You are the one from America. Yeah, I've been stolen from Africa. And then they go to America. Oh, yo, yo.
The young generation awakens on Y254, the leading youth TV station in Kenya. We treat you to current affairs, entrepreneurship, health, and human interest conversations.
It's art, it's culture.
Movies, gossip and trends, sports, drama.
We bring you a vibe like no other, straight to your living room.
To keep you informed, inspired, entertained, and most of all, refreshed.
We are such a vibe.
Y254. Imagine.
KDIC, safer, stronger together.
This October, all roads lead to Kwale County as we honor our heroes. Join us for a comprehensive coverage of Mashujaa Day live from Kwale Stadium as we mark the milestones made in the affordable housing projects.
Nasema karibuni sana, muje mujienjoy, muone yale yote mazuri ambayo yako ndani ya kaunti ya Kwale.
All these will be live on KBC Channel 1 TV, KBC radio stations, and all our socials. Heko kwa Mashujaa wetu.
Flavors of Africa.
Enjoy your favorite shows anywhere. Download DSTV Stream today.
The historic debate in the National Assembly last week was intense.
When the Deputy President is at the forefront demeaning women in leadership.
Kenyans have said that Kitwisen in particular said, kufa makanga, kufa ndereva, kufa mechanic, because Kenyans are more serious issues.
I urge members to find favor with my motion from clause 1 to clause 11, and as you vote to impeach Mr. Rigathi Gachagua.
Rigathi Gachagua has learned his job from his boss, that public officers must be called to order when they fell short of expectation. And I never saw anybody bring William Ruto here for impeachment, for criticizing the IG or the DCI.
From the onset, the mood of the House was telling of the fate that was likely to befall the DP, with the majority of legislators faulting his leadership. And when the motion was voted for,
the ayes, 281. Come forward.
A verdict that set the ball rolling, leaving little legal room for reconciliation or dialogue.
Tuache malumbano yao bungeni na katika Senate na hata katika kotini, lakini sisi tufanye kazi yetu kwa pamoja ya biashara.
And with the horse having left the barn, on Wednesday the DP will face the Herculean task of pleading his case before the senators.
And the Senate shall then investigate the matter in plenary on Wednesday the 16th and Thursday the 17th of October 2024. The Senate is accordingly guided.
August House passed a blanket judgment into him. But when you go to the Senate, it's going to be one item after the other. But then when you look at the 3 counts of where he is being charged and you try to battle each of these, the 11 counts of accusations against him, you find that what happened in the August House is always going to happen in the Senate House, and majority of those charges are going to pass through.
To survive politically, he will need to convince at least 23 of the 67 senators to vote against his removal.
In accord with Article 8 of the agreement, power would be allocated the position of the Speaker of the Senate. He negotiated for himself.
Rigathi is on record stating that he will not throw in the towel.
There was a lot of speculation that Rigathi Gachagua wants to resign.
Legal minds argue that Gachagua and his battery of lawyers can premise their case on the happenings of the floor of the House that led to 282 MPs voting in favor of his ouster.
Issues like public participation and whether he was given an adequate opportunity to prosecute his case. There were issues about some of the videos being shown to him for the first time on the floor of the National Assembly. And then obviously public participation. The public seemed to be against the motion, but the results given by the National Assembly seemed to indicate that the public was overwhelmingly in support. The kind of violence that attended some of those sessions, including at Bomas, he has the chance to go to court. For example, the question whether they should have listened to both the mover and Gachagua first, and then sought public opinion, having heard both sides to the dispute, instead of presenting the public with one side of the story. And there's always the danger of a single side of the story. Those are live disputes before the court.
As the dust settles, the gravity of the political acts before him cannot be ignored.
Irrespective of the statements that we want to put forth in terms of maturity, in terms of the kind of persons we have there, we're in one political field, the Kenyan political field. How politics played in the August House, if we extrapolate that to the Senate House, a majority of 75% voting against him, if that is extrapolated to the Senate House, then we would see a difference. If we borrow what happened to her and the way things have gone, there could be a lifeline. There could probably not be a lifeline, but as soon as the Senate decides, then we have a different playing field that would require another level of intervention, which I don't think would give him a lifeline. From where I'm seated, I think if Senate passes that he has to go, then we go into our history that we have impeached a deputy president for the first time in the last many years that we have been an independent country.
His political career hangs in the balance, and the option for a clean exit are rapidly diminishing with resignation off the table.
On nonsensical allegations, simply because a decision has been made that Rigathi Gachagua is no longer useful to this administration. He is a spent cartridge. His work was to help fight Uhuru Kenyatta and get President William Ruto to power. And thereafter, he is of no use, so he should be dispensed with.
So if impeached by the Senate, what next for the DP?
Okay, so he has the option of going to court. The matter is purely political, with the court having no jurisdiction. But if you look at Article 165 3D, it says that anything done under the Constitution belongs to the jurisdiction of the court. Impeachment is one of the things done under Article 145 and 150 of the Constitution. So he has a right to go to court.
If the DP had opted to resign, he would have been entitled to his benefits.
That if that impeachment goes through and we see the current deputy president becoming a jobless person in this country in terms of political office holding, then the democracy of this country is advancing.
And as the Senate prepares to deal with the matter this week, it is not lost that already there is talk of who shall succeed him as the deputy president if he is ousted by the Senate in a process outlined in Article 149 of the Constitution. It is now a game of wait and see if the Senate will uphold his impeachment and seal his political fate, or if he will survive and stay in office.
He must put that in consideration when he's electing the next person. If this impeachment goes through, who is going to deputize him? He must think, who is this person that when I bring on board is going to act as a neutral factor and a unifying factor to bolster my position as the president of this Republic of Kenya? And he has a huge choice. He has so many persons that he can bring there. He needs also to be forward-looking.
na juhudi za kila siku kuboresha maisha yako. KDIC ndio ngao ya jasho lako. KDIC linzi wa akiba yako. Relax, akiba yako iko salama. Tulia na KDIC.
KDIC, safer, stronger together.
We're here because times have changed, and family ownership of a franchise is no longer viable. It's time to sell the team, Dad. This isn't personal, this is business. If you read the reports, you'd see.
I'd like to speak privately to my wife.
Ex-wife.
See Mr. Cornell through the door. Hey, whoa, just a minute there, Arthur. Because my lawyers can be ruthless as well. Hell! You could throw me out, Frankie, but I'll be here when you get home.
Let's hear those cougars roar, roar!
You are making a big mistake, lady.
So you're gonna prey on her weakness for you to stop her from selling the team? Believe me, I have.
Frankie!
removed from office by impeachment on the grounds specified in the special motion. Whereas by letter referenced REF, NA/DLP/TBO /MTS/2024 dated 8th of October 2024 and received in the office of the Speaker of the Senate on 9th of October 2024. The Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, and further whereas pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 151B and 2 of the Constitution and the Standing Order 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)A and B and C, Article 27(4), 73(1)A and 2B, 75(1)C and 129(2) of the Constitution and Article 147(1) as read together with Article 131(2)C and D of the Constitution. Ground 2. Gross violation of Articles 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandate. Ground 3. Gross violation of Articles 6(2), 10(2)A, 174, 186, 189, 1, and the fourth schedule to the Constitution by undermining devolution. 4. Gross violation of Article 161 of the Constitution of the Constitution on the institutional and decisional independence of judges. Charge 5. Gross violation of Articles 3(1) and 148(5) of the Constitution on the fidelity to the oath of the office and allegiance. Charge 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A.
Give the majority leader the microphone.
So let me take that again. Charge 6. Serious reasons to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A and 62 of the National Cohesion and Integrity Act. Charge 7. Serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Section 45(1), 46, 47(3), and 48(1) of the Anti-Corruption and Economic Crimes Act and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8. Serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9. Gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President has publicly attacked and undermined the work of the National Security Intelligence Services and its officers. Charge 10. Gross misconduct by openly and publicly insubordinating the President, who is the head of state and government. And finally, Charge 11. Gross misconduct by persistently bullying state officers and public officers. Mr. Speaker, this is a very difficult exercise that the House of the Senate is being called to undertake. It's the first time in the history, actually, of this country that this is happening. Though under the old constitution, pre-2010, Mr. Speaker, such an elaborate process wasn't available. To the best of my recollection, I don't remember this kind of an exercise where the Senate is being invited to agree to charges initiated by the sister house and confirm them after listening to both parties that appeared before us in the National Assembly versus His Excellency Rigathi Gachagua the last 2 days. Mr. Speaker, I do this with a heavy heart because His Excellency the Deputy President is somebody that is well known to me. I consider him, Mr. Speaker, more than a colleague in the leadership of this country, more even than just a normal acquaintance in social circles.
Majority Leader, you are called upon to give notice.
Notice? Oh, okay. Apologies. Mr. Speaker.
Next order.
Order number 5, special motion, proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya.
Senate Majority Leader.
Mic, please. My apologies, Mr. Speaker. I now hereby move the motion, which is a proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by letter, reference NA/DLP/TBO/MTS 2024 into bracket 025, dated 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 151 and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate had the National Assembly on grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Articles 145, as read with Article 151(b) and 2 of the Constitution and the Standing Orders 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10(2)(a), (b), and (c), Article 27(4), 73(1)(a), and 2(b), Article 75(1)(c), and 129(2) of the Constitution, and Article 147(1), as read together with Article 131(2)(c) and (d) of the Constitution. Charge 2. Gross violations of Articles 147 and 152 of the Constitution by undermining the President and the Cabinet and effective discharge of the national government's executive mandates. Charge 3. Gross violations of Articles 6(2), 10(2)(a), and 174, 186(1), and 189(1), and the fourth schedule to the Constitution by undermining devolution. 4. gross violations of Article 161 of the Constitution on the institutional and decisional independence of judges. 5, gross violations of Articles 3(1) and 145(5)(a) of the Constitution on the fidelity to the oath of office and allegiance. Charge 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Charge 7, serious reasons to believe that His Excellency the Deputy President has committed gross economic crimes under Sections 45(1), 46, 47(a)(3) and 48(1) of the Anti-Corruption and Economic Crimes Act and Sections 2, 3, 4 and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Charge 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, divisive and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Charge 9, gross misconduct that is incompatible with the calling and the dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President that has publicly attacked and undermined the work of the National Security Intelligence Services and its officers. Charge 10, gross misconduct by openly or publicly subordinating the President, who is the head of state and government. 11, gross misconduct by persistently bullying state and public officers. Mr. Speaker, I have observed that this is such a momentous task ahead, and I never imagined 2 years ago, Mr. Speaker, that it will be possible after the journey that we have traveled with His Excellency the Deputy President in the political side that I belong to, that hardly 2 years down the line, I will have the difficult task of having to move the impeachment motion against him after listening to this case brought to this House by the National Assembly, in the case titled the National Assembly versus His Excellency Rigathi Gachagua. And the last 2 days, Mr. Speaker, together with other Kenyans, we have watched with lots of bewilderment, hard to believe pronouncements, and difficulty, Mr. Speaker, to believe that here is where we find ourselves as a nation. Despite the many challenges that we have gone through over the years, it was our hope, Mr. Speaker, that public officials would have picked up a lesson or two, especially those that are slightly older than yours truly, and many that are younger than me in this House, Mr. Speaker, and that in their conduct, they will reflect better the skills, demeanor, pronouncements of a leadership, Mr. Speaker, that this country continues to yearn for. Unfortunately, Mr. Speaker, listening to the case that has been brought to us by the National Assembly, I have reason to believe, beyond any doubt in my mind, Mr. Speaker, that they have justified the case that they have brought before us and have been able to ably demonstrate to us and to the country, Mr. Speaker, that there is no other cure by design of our Constitution to the challenges, either political or legal or otherwise, that are being faced, Mr. Speaker, by the workings and the working relationship between the President and his deputy, other than by way of impeachment. And the National Assembly has moved this House, Mr. Speaker, on 11 charges, blow by blow, with citations and examples in broad daylight, Mr. Speaker, showing and mapping, Mr. Speaker, that each charge, how it has been committed, Mr. Speaker, and how it violates either the Constitution or various laws of the Republic of Kenya. And therefore, Mr. Speaker, we are left with very minimal options. I have observed before this House, Mr. Speaker, that the Deputy President is personally known to me. I consider him a friend. have had the opportunity to interact with him, learn a lot from him, Mr. Speaker, listen to his wise counsel sometimes. But this evening, Mr. Speaker, duty calls. And when duty calls, Mr. Speaker, there is very little that we can do. I am afraid, Mr. Speaker, that as legislators, as servants of the people, we have to listen to what the people are telling us. Mr. Speaker, we must appreciate that in 2010, when Kenyans went to the polls and brought about change via the new constitution, it was a call for us to have a better republic than had been observed previously since 1963. And there are various high ideals, high demands that have been placed in all of us that are in leadership. And I must add quickly, Mr. Speaker, that as you rise in stature from a member of a county assembly to a member of the National Assembly, senator, governor, deputy president, and eventually even as president, Mr. Speaker, that as you ascend in the hierarchy of leadership, the demands by the Constitution are even more. Number one, because you occupy greater public space, you represent more people. When you speak, Mr. Speaker, you say things that can affect either positively or otherwise the lives of millions of citizens. And therefore, Mr. Speaker, listening to the case that has been laid before us since yesterday by the lawyers of the National Assembly, reading through the bunch of documents that have been presented to us, attached with evidence, Mr. Speaker, I can confirm both to this House and to the country that unfortunately this country must make the difficult decision of having to say goodbye to His Excellency, the Deputy President Rigathi Gachagua, because, Mr. Speaker, the reasons that have been listed have consequences by law of what you do when this happens. The National Assembly has demonstrated before us, Mr. Speaker, that on charge 1, that there are various articles of the Constitution, either through his utterances or his actions, Mr. Speaker, that have led other Kenyans to seriously believe and feel lesser Kenyans, Mr. Speaker, something that we thought we had slayed. We thought that we had worked so hard to build a cohesive society where it didn't matter after a political contest, Mr. Speaker, of who eventually wins, that you'd feel comfortable, you'd feel safe, you'd want to do business in any of our 47 counties, Mr. Speaker, and feel at home. Unfortunately, Mr. Speaker, listening to the utterances, reading through the response, Mr. Speaker, and the pleadings by his lawyers, and the pleadings and the admission, Mr. Speaker, by his own affidavit, Mr. Speaker, that either my good friend, the Deputy President, doesn't appreciate the higher calling that the office he occupies demands of him, or he has completely refused, Mr. Speaker, to accept the dictates of our Constitution. And when you get to that law, that place, Mr. Speaker, where there is conflict between man and our Constitution, then man must give way for our Constitution to thrive. That is a demand of a public office. Mr. Speaker, I know this is not an easy exercise. I have agonized and sat there wondering whether there could be other ways we could resolve this issue. And I know for a fact that there have been attempts, Mr. Speaker, not just this time, but previously. I know for a fact, Mr. Speaker, that there have been occasions where either religious leaders, friends, people from business circles, Mr. Speaker, have attempted actually to mediate through some of these conflicts. But unfortunately, Mr. Speaker, instead of getting better, things have gotten worse. What is the essence of this session that we are having? Mr. Speaker, after listening through an impeachment process, the Senate sits as a jury to make a decision whether to find guilty or acquit. But like has been observed many times, and I have reminded this House on all the occasions when I have moved impeachment motions the last few years, Mr. Speaker, is an impeachment is political and legal conjoined together. It's about political accountability. It's about legal consequences of our actions as well, Mr. Speaker. There are political challenges, Mr. Speaker, that must be addressed. There are legal issues that have been raised as well, Mr. Speaker, which I want to believe when my colleague senators get the chance to address this House and convince each other. Perhaps people are watching and wondering, what is it that senators are doing at this hour? I believe that all the 67 of us that are here have had occasion to peruse through the evidence.